Welcome to the We've Seen a Thing or Two podcast. As investigators and mediators focused on regulatory and workplace conflicts, we have seen a thing or two and learned a thing or two. In each episode, we will be speaking with industry leaders in regulation, human resources and law, as well as thought leaders and top performers in investigations and mediation. We bring our audience interesting and cutting-edge information on conflict management as it relates to professional regulation and workplace disputes. This industry is one of many views, and we have to say that some views shared by our guests are not necessarily shared by the We've Seen a Thing or Two podcast, its host, or sponsors. Today's show is brought to you by Benard Associates, trusted investigation and mediation professionals since 2004. Now here's your host, Dean Benard.
Hey everybody, and welcome to the podcast, and thank you for listening. Now, as our listeners know, we like to provide a range of perspectives and information that will be of interest to investigators, human resources professionals, and professional regulators. And today, we're bringing an international twist to the show with a great guest who I have personally followed very closely on LinkedIn. I love his insightful and sometimes actually very humorous posts, and I'm very excited to introduce you to John Farren. Now, let me tell you a little about John. He is the co-founder of Farren McRae Workplace Lawyers and Consultants, located in Brisbane, Australia. He has extensive experience in all aspects of workplace and employment law. He's advised and represented numerous employers and employees across the public sector, not-for-profit, statutory authorities, and private sector before workplace and industrial, administrative, and statutory tribunals and courts at both state and federal levels. That's a mouthful. John has said that his area of special interest and experience lay in dispute resolution through both advocacy in the courts and tribunals and skilled negotiation. John is also a trusted legal advisor to both employers and employees in relation to a wide range of employment law issues. In addition to his legal experience, John has over 20 years' experience in undertaking complex workplace investigations related to misconduct, corrupt conduct, bullying, and workplace harassment, as well as serious disciplinary matters, including code of conduct breaches. He's also dealt with grievances, discrimination, and workers' compensation issues. So he's dealt with everything, folks. He's also an experienced workplace mediator, having developed his own distinctive style of mediation that focuses on assisting the parties to identify the root causes of their conflict and agreeing upon how their working relationships can move forward in a more positive way. And if all of that weren't enough, John has an impressive record of volunteer and pro bono work through the board of the Aboriginal and Torres Strait Islander Legal Service Limited, and previously serving as an independent board member on the National Board of Management of the Salvation Army's Employment Plus. Now, John and I have often commented on each other's LinkedIn posts, and we've established a bit of a connection through that platform where I appreciated so much of his content. I felt he'd be a great guest for the show. And so with all of that, welcome to the show, John.
Well, Dean, thank you very much for having me on the show. It's an absolute pleasure to be here, and I'm looking forward to our chat.
No, it's great. And it's funny because I feel it's interesting because of your mediation background and your investigative background is something you don't see a lot of, where somebody has the sort of skills in both of those areas and can, I'm sure draw on those different skills in different scenarios to assist them, regardless of whether it's a mediation or an investigation that you're doing.
Yeah, absolutely. And certainly, at least here in Australia, unfortunately, mediation is often seen as a last resort rather than a first resort, which is what I advocate to clients, because obviously investigations can carry a heavy toll on workplaces and the participants. And if a matter is appropriate for mediation, certainly I think that is worth having a try at. Not only because it has less impact on the workplace and the participants, but it also means that resolution of the dispute remains in the hands of those people who are involved in the dispute. It's obviously also a lot cheaper and a lot quicker for the organisations as well than investigations. But yeah, I do like to mix it up a bit.
Yeah, well, I'm saying preach because I'm 100% on board with that. I really feel strongly that mediation should be a first resort where it can be. So anyway, that's not what we're here to talk about today, but I just think it's an interesting connection that we have that way. So what are we going to talk about today, folks? Well, today we're going to focus on a few different workplace investigation topics that we sort of felt might warrant some further discussion. Obviously, we can't delve into these super deep, but we're going to talk about them and just sort of scratch the surface of them to the extent that we can. One of them is the area of investigation of unwitnessed situations or the unwitnessed scenario, one person's word against the other. What do we do? How do we manage those types of situations? Another issue we're going to talk about is selecting external investigators and the proliferation of the would-be investigators. We're seeing them, frankly, come out of the woodwork all over the place these days, and I'm not sure that all of them really have the chops to do the job the way it's meant to be done. And we'll talk a little bit about that. And then finally, if we have some time, we're going to talk about avoiding bias and staying open-minded during investigation, which is really important. So with that said, John, why don't we start with the unwitnessed scenario? Frankly, if I had to choose the most asked question that I get, it's how do I manage the he said, she said scenario? So I'm interested in your thoughts on that.
Yeah, certainly I come across when I review other investigations, because obviously, as you've said in your opening, I have got over 20 years experience conducting workplace investigations, but also within my legal practice, I review a lot of investigation reports, either when I'm acting for employers or employees. And one of the most common scenarios that I see that investigators struggle with is this classic he said, she said. That is a situation where there isn't an independent witness who can give evidence as to what happened. I think in summary, the three main areas I think investigators struggle with, or that lead to poor investigative outcomes and reports, are the failure to consider whether there is other relevant sources of evidence, what I sometimes call the hidden sources of evidence. So they assume that, well, there's no witness, so there is no corroborative evidence, and it may in fact be that there is some other evidence out there, and I'll talk about that in a bit more detail. The second is superficial interviews that don't test appropriately the reliability and plausibility of evidence, and that just skate across the surface of the issues rather than delving into interviewees' evidence in a sufficiently deep way so that you get what I call the building blocks for credibility assessments, which is critical to the next problem area, which is superficial, illogical or irrational analysis when the investigator sits down to prepare their report. So in terms of that first issue, the hidden sources of evidence, even when there are not corroborative witnesses available to an investigator in respect of a particular allegation they're investigating, there are often other sources of evidence that will either be direct evidence that either proves or disproves the allegation, or potentially some circumstantial evidence that can be given appropriate weight if it is relevant. And so the sort of things I'm referring to here are CCTV footage, call logs from landlines, mobiles, text messages and the metadata that sits behind those messages, emails, calendar entries, contemporaneous notes that might have been made by the participants in the investigation close to or at the time that the events happened, photos, videos, voice memos, even swipe access cards, so the proximity cards that many workplaces have their employees use to enter and exit, and particularly to enter workplaces, and more these days when they actually exit it as well. So if we just take that one alone, if there is a dispute between the parties as to whether one or both of the parties were in fact even at the place at the date and time the alleged event is said to occur, well then things like swipe access logs can be very, very powerful evidence to either prove or disprove in terms of placing the people at the place where the alleged event is said to occur. There's certainly many more things that sit behind that list, but given the time that we've got today to discuss it, I think that's sort of indicative, at least, of the sorts of things that investigators should at least be talking to their case managers about, if they're external investigators, to see what types of evidence might be available based on the scenario and also the equipment and technology that's used by the organisation. The second issue about superficial interviews, the old saying about the devil being in the detail is supremely important when you're investigating any event, but particularly unwitnessed events. It's easy to say, but it's so often forgotten, and which results in these superficial interviews. So an investigator, with every person that they actually interview, whether it's a complainant or a respondent, or even if it is a witness in a witnessed event, needs to really dig down into the detail of the evidence. That is the who, what, when, where, and how. So it's not just what happened, but where did it happen? Who did it involve? When did it occur? The details of, for example, volume of voice, tone of voice, positioning of the parties. Were they standing? Were they sitting? Were doors to meeting rooms closed or shut? Who might have been sitting outside the meeting room of an unwitnessed event and might have either heard what occurred in the room, or they might have witnessed the aftermath, by which I mean what happened when the people left the room and their observations of them. So unless the investigator really digs down in that, they don't have these, what we call the building blocks of credibility assessments. Now, when I said before, the investigator should appropriately test the reliability and plausibility and credibility of an interviewee's evidence, what I don't mean by that, and this is a problem for some lawyers, particularly litigation lawyers that go into workplace investigations, is that you're not to cross-examine the people. You certainly test the evidence, you ask them to explain any inconsistencies that are apparent to you. You might put to them propositions that might be on your mind. For example, if you think something that is being put to you appears to be inherently improbable or unlikely, then I would always put that as an observation to the interviewee to give them a chance to comment on that. And when you do all these things, then you've got a lot of rich material to refer to when it comes to undertaking those credibility assessments that need to occur in the analysis stage so that an outcome can be achieved from the investigation. That is, has the allegation been substantiated to the appropriate standard of proof, or has it not been substantiated? Probably the most annoying thing I see, Dean, in these reports is this, what I call a no-finding finding. That is, well, it's he said, she said, so really I can't come to a position that the allegation is either substantiated or not substantiated. Of course, we know as lawyers, Dean, that's complete rubbish. Tribunals and courts make these types of assessments every day of the week. And in fact, if you think about criminal trials and findings of fact, which are made on the higher standard of beyond reasonable doubt, we had a case recently, a murder case in Australia, where a chap was convicted by a judge sitting alone rather than a trial with jury, where there was zero direct evidence that either the wife was dead or that the husband killed her. The case was entirely circumstantial, but it still provided a compelling basis for a finding of guilt. They don't even have a body. So the fact that the woman has been found to be dead was all done by inferences drawn from circumstantial evidence. So if they can do that, workplace investigators, in my view, can certainly come to a conclusion as to whether an allegation has been substantiated or not. Apart from that, the usual credibility building blocks that I've mentioned a few times include questions as, is the evidence reliable? Is it plausible? Is it externally consistent? And by that I mean, is the evidence that you're receiving from the witness consistent with other sources of evidence that bear upon it, documents, maybe previous statements made by the person, that type of thing? Is it internally consistent? That is the person's story staying consistent with their own story over time? And is it given in a credible way? Now, when I say that, the point that really does need to be made about observing demeanour and things like that is that it's been well established now for a number of decades that to judge somebody's credibility on their demeanour alone is completely unreliable. In fact, the studies, particularly out of the US, show that with the exception of Secret Service officers, most people, including judges and lawyers who think they're very good at judging credibility, are in fact very poor at it, and that you don't have a better than a 50-50 chance of being right about it. So you've got to use these other types of building blocks to come to those credibility assessments. And Dean, the third one that I mentioned, superficial, illogical, irrational analysis. What I tend to see in many reports is either little or no summary of the key evidence in that section so that the reader of the report knows what evidence the findings are based upon, either little or no analysis, or analysis that is illogical, like they jump from A to Z without anything in between the two steps. So you're sitting there thinking, holy hell, how did they get from that point to that point in making their findings? And also no credibility assessment. While I say that an investigator should place themselves in a position where they can decide who ought to be believed in a case where the evidence is in conflict, it's not sufficient, in my view, to simply say, I believe this person over that person. There must be some rational basis for drawing that conclusion. So I think there are the three main issues that I see come up in the unwitnessed scenario. Obviously, we could talk on those issues all day long, but I know that we have a particular time frame for the show, so I'll leave that particular issue there.
Well, that was actually wonderful. I think a very comprehensive overview of the issues that arise from the whole he said, she said scenario. And I agree with everything you say. In fact, before we started recording this session, I had told you about these videos that I'm creating, these new video series. And for a minute there, other than the difference in our accents, you sounded like me in one of those videos, because I'm 100% in agreement with every single word you said. I love that point you made about getting into the details. It really is very, very important. And I won't belabor it because you've covered it so beautifully. So I will just move on to the next topic. And another topic that's, frankly, kind of near and dear to my heart at this point is this proliferations that we're seeing of what I call would-be workplace investigators. And I'm not trying to disparage anybody, but I think it does often consist of people with really no proper background or experience. They're holding themselves out as qualified workplace investigators. And this is not a regulated field in Canada. I feel it's becoming an issue for consumers to locate people who can really do the job well. Is this something that you're seeing in Australia as well?
It is. In Australia, it is an unregulated profession as well to do workplace investigations. Private investigators are certainly regulated here, as they would be in most countries, but not workplace or administrative investigators. It's a problem in the sense that there is no base standard for training and qualifications, although there are a couple of qualifications that are accredited in Australia. There's what's called a Certificate 4, which is a form of occupational training certificate. I think there's one in workplace investigations. There might be one in government investigations. But in fact, my experience as observation about those courses either are that they are not, in fact, very high quality, despite the fact they've achieved some recognition as accredited training. But also, I'm not sure how the occupational training industry works in Canada, but in Australia, when you do occupational training, you can ask to have a recognition of prior learning and experience. In fact, I've known people who aren't particularly experienced workplace investigators who have relied on what little experience they have to get complete graduation from these certificates by recognition of prior learning. So they have, in fact, learnt nothing, even though they have actually achieved the qualification. I think there are some universities in Australia that are now looking at developing or are offering some courses in the area. But beyond that, it's really you're just looking at occupational training now. For example, our firm has released a few months ago an e-learning course called, funnily enough, Getting Beyond He Said, She Said, which specifically covers those issues in a lot of detail and in a really interactive way. Sorry for getting my plug in there. I had to slip that in somewhere.
Oh, that's okay.
And part of the reason that we developed the course, and it took us 18 months to develop it with our learning designer, is that we looked around the marketplace and there was not really any high-end, advanced, interactive, interesting training in the area, particularly in Australia. There is some really interesting training going on in the UK and also in Canada with yourself and the likes of Bob Stenhouse. And so there is stuff around, but not a lot of it. The main issue I find, and it's not exactly because the workplace investigations field is unregulated, but it's more to do with the sort of investigators that it attracts, or more properly put, the backgrounds of those investigators. So classically, the three main occupational groups that I find end up doing workplace investigations are either lawyers, ex-police, or psychologists. There are obviously some HR people that fall into it as well that may not have formal qualifications in any of those areas. Those are the main three where I'm not saying that those are not appropriate backgrounds, but there are issues that often arise in my observation because of the backgrounds of those people and the differences in attitude that you need to take towards conducting a workplace investigation. So, for example, lawyers. Law firms in recent years have become, at least in Australia, more active in this area, undertaking workplace investigations, partly because I think they realise it's a very lucrative area and workplace investigations tend to burn through billable hours very, very readily. So they've seen that this is a potential cash cow and the law firms are getting into it. The problem with lawyers becoming workplace investigators, particularly if they're litigation lawyers, is that they find it difficult to get out of that adversarial, partial mindset that is entirely appropriate when you are a litigation lawyer and you are appearing in an adversarial court proceeding for a particular party, but is completely inappropriate if you're meant to be an independent, impartial workplace investigator. And I see that manifest in different ways, but probably the most common is when they're testing the credibility of evidence. So as lawyers, they understand the importance of that, but when they go in to do this, it usually looks very much like cross-examination. And the problem with cross-examination is that the way it's done in courts, and this is pretty consistent around the world, is that it is done in an entirely partial way. That is effectively putting your client's case to the witness to be able to get them to respond to it. And it's done usually entirely with leading questions, which are obviously generally to be avoided in a workplace investigation. So that's the problem with lawyers. Ex-police, a little bit similarly, I find that they have difficulties getting out of the prosecutorial mindset. So when they're normally investigating crimes, very good police obviously follow the evidence and where that takes them, but there is still a primary mindset that we are investigating this for the purposes of prosecuting an offender eventually. And so that can lead, again, to somewhat adversarial approaches, particularly to interviews. And the other thing I find with police too is that they often apply too high a standard of proof to workplace investigations. So they can't get away from the fact that they know when they're collecting evidence as a police officer that if a prosecution ensues, it'll be on the higher standard of proof of beyond reasonable doubt. And so I've seen investigations that I've reviewed that were done by ex-police where they have found allegations to be unsubstantiated when there in fact was sufficient evidence to make a finding of substantiation on the lower civil standard of balance of probabilities. So I've seen that a little bit too. And the final category is psychologists. I generally find because of the communication skills that are built in psychology, they actually often are very good interviewers and very impartial interviewers. But unfortunately, sometimes I see psychologists whose approach to interviewing is more like therapy, and they forget that an investigative interview is not therapy. It might have some cathartic effect for the person who gets to tell their story and get it off their chest to an independent person, but that is not the primary purpose of an investigative interview. The other thing sometimes I find with psychologists is that they will sometimes inappropriately use language or responses that are entirely appropriate in a therapy session, particularly responses that are meant to be empathetic or sympathetic to the person who's before them. For example, like saying, wow, it sounds like you've really been treated terribly. Now, that's entirely appropriate in a session for therapy, but if that is said in a workplace investigation, could be used against the investigation by way of an allegation of prejudgment, that you have in fact accepted the story as truth from the interviewee when you are not at that point yet where the evidence is closed and you should be drawing your findings. So I've seen that happen. And in fact, over here in the government sector, where you have the option of, say, attacking an investigation by way of application to the Supreme Court for judicial review, which is something private sector employers don't have, prejudgment is one of the most common sources of attack. That is the language that has the investigator used language that raises a reasonable apprehension of bias through prejudgment. So I'd say they're probably the three main issues I see with people who are getting into workplace investigations generally.
I would agree, again, with all of that. I mean, I think here we're seeing the same issues, the same kinds of concerns. I share them all. I feel like you're right. Like, for example, private investigators are licensed to be investigators. One of the things we see here very commonly is sort of this, I call it the jack of all trades and a master of none. It's like, well, here's the list of things we can investigate. And there's, 52 different kinds of investigations that we can do. I've been investigating now for, over 2 decades, and I do 2 kinds of investigations. That's it. If somebody came to me and asked me to do an intellectual property investigation, I'd refer them to somebody who specializes in that. What I find is that, as you know, the point you made about it being lucrative, and it has the potential to be lucrative, is that people want a piece of that. And so they're very willing to put themselves out there as qualified to do these investigations, sort of with this attitude that, well, an investigation's an investigation's an investigation. But clearly it isn't. And I'm a little encouraged to see some organizations doing something. For example, here there are a lot of human resources professionals that conduct investigations either internally as part of their own organization that they're employed by or as consultants. In Ontario, the Human Resources Professionals Association actually created a standard of workplace investigations to give them some parameters in understanding what is expected of them and what is expected of a good and appropriate workplace investigation. So I'm starting to see some of this stuff happening, which is encouraging. But I agree with you. I've seen some great lawyers, great police officers conduct investigations. They're wonderful at it. I have a couple of former police officers that work for me. I'm one. So you mentioned Bob Stenhouse. He's one. And I think it's about a mindset, though, as you said. It's not, if you're a police officer, you could be a great workplace investigator or a horrible one. And it's really going to come down to whether you've embraced the principles of an appropriate approach to doing those types of investigations.
Yeah, absolutely. And you're 100% correct. It's all about the mindset. It's shifting that mindset. And for example, I am a litigation lawyer. I litigate almost every day. I'm working on litigation files in my legal practice. So I have to switch that mindset as I move from litigation files to investigation files. And even for myself, I need to be conscious that I am making that shift appropriately, for sure.
Right. Makes total sense. Well, as you said before, in the interest of time, I'm going to jump us to the next topic. And this one, I guess it ties in a little bit to some of the things we've already talked about. But I wanted to talk a little bit about the need to avoid bias and staying open-minded in investigations. So often we hear about particularly criminal cases where somebody will, or an investigation will have sort of a theory, and the investigation is all about proving that theory, rather than all about gathering all the information and then developing a theory based on the evidence, as opposed to having the theory and pursuing that theory to be correct. So I know we can't do this topic justice in just a short time, but I'm interested in your thoughts on this and what maybe some of the key things are that people can do to avoid falling into this dark hole.
Yeah, it is a big topic. And I think putting aside a big chunk of the topic, which is the issue of conscious and unconscious bias, so just being thoroughly aware and conscious of the types of biases that we all carry around with us, I think that's certainly very important. But just putting that big issue aside for 1 minute, the main things are simple to say, sometimes difficult to do. So keep an open mind. I mean, really keep an open mind. That means following the evidence and specifically not drawing conclusions until the evidence is closed and you're sitting at your desk in front of your laptop and undertaking the actual analysis and findings stage of your investigation. And I say that in those terms because I think that's an easy way to understand precisely what an investigator needs to do. How they go about doing that within their own personality and their own experiences, that is a different thing. But it is as simple as that. Now, that's not to say that investigators don't get preliminary impressions of the evidence. And that's also not to say that if you have some preliminary impressions forming in your mind, that it may well be part of the obligation to afford procedural fairness to the participants to in fact let them know of that so that they have an opportunity to comment on it. The technique I often use in investigations where I'm thinking ahead in my mind as I'm listening to particularly the subjects of an investigation or the respondent is that I might form a preliminary view that the evidence before me may be assessed in a particular way. For example, something I'm hearing sounds inherently implausible. It just sounds off the wall, like it is really unlikely to have happened the way they are saying. And so the technique I usually use is this. I will say to an interview, look, some might say that that version you've just given me is inherently improbable because of this, this, and this. Now, what would you say to that? So in doing that, you're not giving rise to a reasonable apprehension of bias, for example. And certainly the cases in Australia about judges, for example, forming preliminary views of the evidence before them is that they should, in fact, put those preliminary views to the parties so they have a reasonable opportunity to make submissions upon it. Otherwise, that may well be a breach of natural justice and procedural fairness in the hearing. And I think that principle can apply to workplace investigations as well. So with that aside, though, back to what I said, you've got to keep an open mind and keep that mind open until you're sitting down, the evidence is closed, and you're sitting and you're doing your analysis and findings.
I couldn't agree more. And sometimes, too, I think it's important to ask yourself, can I be unbiased in this situation? I often refer to a case that I had to investigate once. I can't get into a lot of details about it, but I had serious reservations initially as to whether or not I could remain unbiased because of the individual involved. I didn't know the person personally, but I did know of certain acts they'd engaged in. And for me, I had to really stop and ask myself, can I be unbiased in this? Can I give this person a fair and neutral assessment of the evidence and pursue things in a way? And so I think as investigators, we owe it not only to ourselves, because all of this can reflect very poorly on us, but we owe it to the people involved that we ask ourselves that question as to whether or not we can truly be unbiased and approach the work that we're doing in a fair and neutral manner.
Yeah, absolutely. And if you're around doing these investigations for long enough, you will sometimes come across one or two parties who have previously been involved in an investigation you've done. Very much more common for internal investigators. And so, for example, if an investigator in a previous investigation has made adverse findings against a participant, and that participant has come up again for a new matter, then in my view, that investigator is clearly conflicted. And that, for example, may well ground an appropriate argument of apprehension of bias, particularly if you've made commentary in a previous investigation on the person's credibility. That, I think, is fatal for the involvement of the investigator in the next matter that's come up. And like I said, that's more likely to come up when you're an internal investigator and you're coming across the same people sometimes as the years go on and new matters come up. And in my view, I mean, I always take a belts and braces approach to this sort of thing. If there is the faintest suggestion that I might be conflicted in a matter, I let the matter go. Give it to somebody else. One job, more or less, does not make a career. I was told many, many years ago, and I think that's good advice in terms of, particularly when you're an external, and turning down work sometimes can be hard.
Yeah, it can. But, just as one job won't necessarily make your career, if you make a very poor choice, one job could definitely hurt your career. So
absolutely,
it's that's wise words, I have to say. Well, I'm going to move us on because obviously we've got to get through this. We've been talking for a while now and it's been wonderful. And I've really enjoyed your thoughts and your insights, John. One thing that we've done on this show is we've made a practice of giving listeners a little insight into our guests in terms of what their off-work interests might be. What are some of the things that are, near and dear to you that occupy your time outside of your core work?
Oh, that's an easy one for me, Dean, and that's travel, particularly international travel. For various reasons, I didn't travel overseas for the first time until I was 47, and in a week or so I turned 54. So I've been making up for it ever since, and trying to get overseas as often as I can, as well as seeing one of the upshots of coronavirus pandemic is that because we are locked down into Australia as an island for many, many months, once we started coming out of isolation periods and lockdowns internally, it did force us to go and see more parts of Australia that we haven't seen before. And we took some wonderful trips during that period around beautiful parts of Australia that I hadn't seen before. But overseas travel, I'm a big believer in having as much and as frequent occasions of awe in your life, or as in AWE. That certainly is satisfied by going to places that are beautiful and awesome and different from where you're from. And of course, obviously our Indigenous peoples in Australia have been settled in here for many tens of thousands of years, but modern, you might call white Australia, is only a bit over a couple of 100 years old. So when we start going to countries, particularly in Europe, the architecture and the buildings are sometimes thousands of years old. It's an extraordinary experience that you cannot get in Australia, other than sometimes if you go to some of the Indigenous sites to see the artefacts and that sort of thing that are in fact tens of thousands of years old. So that's probably one of my most enjoyable things to do outside of work, different cultures, different food, different architecture. it's all good as far as I'm concerned. The one place I haven't yet got to is Canada, and I'm really looking forward to getting over there sometime.
I feel the same way about Australia. My partner and I we've wanted to go to Australia for a long time, and it will happen. I'm an avid scuba diver, and I've always wanted to dive the Great Barrier Reef. So yes, I mean, I agree with you. Travel for me is one of my big loves as well, and seeing as much of the world while I'm on it is extremely important to me. So I could definitely relate to that. Well, John, absolutely. I want to thank you so much for agreeing to be a guest on the show. And I know our listeners will benefit from your insights. And it's really been a lot of fun and entertaining to hear your thoughts. You know I'm walking away with a few great ideas and thoughts that I hadn't really explored as deeply as some of the things you said. And I know that some people will want to connect with you. So what's the best way for them to do that?
Well, if people are on LinkedIn, that's my main social network that I interact with, as you'd know. So they can just search my name, John Farren, Farren, on LinkedIn, and I'm sure they will come up. I think the only other John Farren that I often come across, if you Google that name, I think was the ex-counsel to one of the presidents, Bush, who ended up jailed. So unfortunately, I do share a name with that notorious person. But if you look up on LinkedIn, I don't think he's on LinkedIn. The other, apart from that, our firm's website is www.farrenmcrae, that's FARRENMCRAE.com.au. So you can find out anything you want to know about me and the firm and what we do through our website.
Oh, that's wonderful. Thank you so much. And I'm sure you definitely will get some contacts happening through this podcast. So I will end it there now, folks. That's it for this episode. Again, I want to thank you all for listening, and please send us your comments and your suggestions. And our goal with this podcast is with everything we do, and I say this at the end of every podcast, so I'm a broken record here, but it's all about constant and never-ending improvement. And we need your feedback to do that. So let us know what you think so we can keep bringing you interesting and helpful content with each new episode that we produce. All our podcasts get linked to our website, benardinc.com. You can find us on the Benard Associates YouTube channel. And to reach me, you can email me at dbenard@benardinc.com or find me on LinkedIn by searching Dean Benard. So thanks again for tuning in. We'll see you next time on the We've Seen a Thing or Two podcast. Bye-bye, everybody.